So hello, for those of you who are listening to that first conversation. My name is Deborah Murad, and I'm the Director of Business Affairs at the Dramatists Guild, and I am here with my colleague, Kristen Capinos, who will be chiming in later with all of your wonderful questions, and I'm sure you have many, and I hope you brought many. We talked last week about legacy planning, the ways that to begin to start thinking about how to plan for your legacy, for your name, for the story that you want to leave behind, for the story that you want to tell. We talked about oral histories and written histories and collecting memorabilia, how to contact an organization who might be interested in housing some of the physical things that you've collected. And today we're getting into the legal side of things, the estate planning portion. We want to consider how do we make sure that everything that we want to happen to our works actually does happen when we're not here to make sure that happens. So this is part 2 of our series of Who Tells Your Story? Planning a Legacy, Planning Your Estate. So this is part 2. And next week we've got part 3 with where we're going to be talking to a literary executor about the types of troubles they may encounter and how to best prepare your literary executor for the job that they may take on. But for right now, we are here with Catherine Sloan, who we're very honored to have with us today. She's an attorney with Walden, Mocht, and Harron, which I hope she'll correct me if I said that incorrectly, where she focuses on estate planning, trust and estates, estates administration, business planning solutions, and she has many, many of the answers that you're going to be looking for today. She's an incredible attorney, but I hope you'll realize that at the moment, at least, she's not your attorney. She's just giving us a general overview of all of this. So you're always invited and encouraged to seek your own legal counsel or contact Catherine afterwards. If it's okay with her, we'll provide her contact information afterwards if anyone wants to reach out to her directly. So I'm going to hand over the webinar to Catherine, and we will talk a little bit more about the DGCM, which is the sponsor of this event, a little bit later. So without further ado, I will.
Okay. Great. I didn't realize that you had a part 3 planned, and I think towards the end of my talk, we will lead to the appointment of a literary executor or trustee and what that means. And I'm glad to hear that you'll have even more time to talk about that role.
Yeah, we'll be talking actually with David Saint, who's the literary executor for Arthur Lawrence's estate. So it'll be interesting to hear, you know, how he makes his decisions. And but
okay,
we want to know how to prepare that person from your perspective too. So
sure, great. And as far as questions as we go along, how do you?
I think we're going to let you, if we have burning questions, we can insert them if they seem relevant, Kristen. But I think otherwise we'll let Catherine finish what she wants to say without too much interruption.
Okay.
If that's all right.
I'm happy to receive the questions as we go along.
Okay.
But let's just see how we go. So I'm happy to have a platform in the middle of this pandemic to talk to people about some issues that are probably on weighing heavily on everybody's mind right now. And as you can imagine, my practice has been active over the past 2 months of everyone in New York City being home, thinking about their health, thinking about the health of their loved ones. So what I wanted to do is to start with just some issues that affect everybody, not just writers, and are affecting everybody now. The first thing I wanted to talk about is advanced directives for healthcare, because that's just something that's really on the forefront of everybody's mind right now. And if it's something you haven't considered, or you considered it a long time ago but haven't reconsidered it, it's something to think about in terms of COVID as something you might want to look at your documents again. Just to summarize, what am I talking about? You can, an advanced directive in New York, usually takes two forms. It's a healthcare proxy, where you name an agent to make healthcare decisions for you, and then a living will, where you give your instructions about your care and what you wish for. And these are both in the event that you can't make these decisions on your own. Those can be two different documents, or they can be combined into one document. Right now, in terms of COVID, it's my preference that you have two separate documents where you name somebody as your agent and you separately have your instructions, because right now it's possible that your agent is not with you throughout your medical issue, is not allowed to join you, and might be basically kind of cut out of the conversation. And what I don't want to see is your healthcare provider having this document that, and they get to interpret your wishes rather than your agent. A lot of these documents also have very general descriptions about a wish, a do not resuscitate order, which prior to COVID might have made sense to just have some general language, because this, no one ever turns to these documents until somebody's 107 years old. But it's possible now that those general do not resuscitate orders could be interpreted to mean I don't want a ventilator or a respirator. And in the world of COVID, that's no longer what you probably meant. So I think if you have these documents in place, now is a good time to read them carefully and think about updating them in light of the world we're living in right now. That's my first pitch, and I know it couldn't be gloomier, but we will get actually to death, not just dying, so it will get actually gloomier. Let's move on to again, we're going through documents that I think is important for everybody to make sure they have in place, not just writers. One more thing I wanted to say about the healthcare proxy is once you have that in place, who should hold that? You should give copies of that to your agent. The proxy should go to your doctor, but not the instructions. What I'm saying is separate these two things. Let your agent have your instructions, let your doctor have the proxy, so that they know who they should call to discuss your health care.
Can I just ask, when you say agent, who you're talking about? Because
yes,
and agent,
and as
and I don't want to
preparing this, and I'm thinking about literary agents and licensing agents, and in the legal world, we use the word agent many times, and right now I'm talking about your healthcare agent. So that's who you name as your proxy in the healthcare proxy. That person is also an agent with a capital A. And then the next thing I wanted to talk about is a financial power of attorney. And this is a document that many people have in place that allows someone to step into your shoes for financial matters if you need somebody to. And again, you appoint an agent, and that agent is your financial power of attorney, your agent and your financial power of attorney. Different agent, capital A. And this has been an important document with the growing population afflicted with Alzheimer's and dementia, that it's an important thing that families want people to have in place, so that because you can't always plan, obviously, for the time that you're going to need to transition your finances over to somebody else. So we usually use a form that's called a durable power of attorney, which means it's in effect as soon as you and the agent sign it. So the agent could act on your behalf immediately. And not everybody's comfortable with a durable power of attorney, because maybe you don't have anybody in your life that you trust to appoint as your agent today that could actually, act, do everything that you can do for yourself financially. So we can also use a springing power of attorney, which means you put the document in place, but it doesn't go into effect until you are deemed incapacitated. And you define that by a letter from a physician or a letter from two physicians or something like that. And that would, make it makes life a little more complicated for whoever you're appointing as your agent when they need it, but it may give you some peace of mind that your agent's not going to go in and steal all your money today. And then the third option, if you don't do that and you needed somebody to step into your shoes, is you'd have to have your family member or loved one would have to apply to a court to become your guardian. And that's definitely a complicated and costly process. So the preference is to have this document in place so that if you need it, if your family needs it, they have it. So that's all I really needed to say to you. Is there any questions about that topic at this point, do you think?
I had to mute myself. We have one. If one already has a good estate plan, including advance directive, can one draft an amendment specifically for literary properties, or does one need to draft a whole new estate plan?
It would depend on the plan, and if we're going to get to that a little bit later about whether or not you specifically address copyright in your estate plan. You can always amend your documents, and you can always create what's called a codicil to your will, which may just be a direction regarding one specific thing, but you'd have to still go through the same formalities as when you signed your will the first time. Any change to a will, you still need to sign it in front of two witnesses, and it may not be a complicated process to do that, but you just would need to update the will with the same legal formalities.
Okay, and then we have another quick question. What was the name of the power of attorney that doesn't go into effect until you need it?
Springing. Okay. Okay, so let's move on to the fun topic of death and what happens to your assets, including the rights to your written work after you die. I always like to remind people, and I know that we probably have a wide range of experience with estate planning in this group. So I apologize if I'm going to the very, very most basic level, but I think it's important, and I am always surprised at how some issues people just never really realized, or they never thought about it, so they don't know it. So I like to remind people, what happens if I do nothing? If I don't have an estate plan and I live in New York, what happens to all of my assets? And it's called the rule of intestacy, and it spells out what happens if you die without a will. And a lot of people, when they think about this, it really motivates them to create a will, because it's really like the New York State's version of your family tree, and it'll say, if you're married, do this. If you're married with children, you do that. If you are not married and you have no children, and it goes through your family tree, and it distributes your assets equally to who is considered your next of kin. So it may be your parents, your siblings children. If you don't have any siblings, it would go then to the descendants of your grandparents, so your aunts and uncles, your first cousins, and it can be kind of mind-boggling that, oh wait, I didn't realize that this cousin that I haven't talked to in 50 years would inherit my assets, including the rights to my copyright, if I don't do something. Or or even you have closer relatives and you just can't stand them, and you'd rather take action so that your friends or your preferred charity receive your assets, and not the family members that you don't particularly like. So I just like to remind people of what the rules of intestacy are. And then I also think it's important to just remember, well, so if I draft a will, what exactly is going to pass through that will? And maybe you've heard that people refer to probate assets and not probate assets. And I think it's also an important thing to understand, that I may have this elaborate will and with this great plan of how all of my assets will pass, but then really my largest asset is maybe a retirement account, and I've named my sister as the beneficiary of that retirement account. That passes outside of my will to my named beneficiary, and then there wasn't actually anything passing through my will, except for my copyright, of course. So that's something I just wanted to mention, that there are probate assets and non-probate assets, and anything that has a named beneficiary, so a pension, a retirement account, a life insurance, an annuity, that's always going to pass directly to whoever you named as your beneficiary. So it's always a good idea to remember who you've named, update those accounts, you know, as the circumstances in your life change, and keep that in mind when you're making a overall plan. Also remember,
we have a couple questions actually
Sure.
relating to that. So someone wants to know if we can have a backup person in the POA or the HCP role.
Absolutely. For the healthcare, you may only name one person at a time, but you can have a backup. For the financial power of attorney, you can name co-agents, and you can state whether or not they can act independently or if they have to act together. And then you can also name backups to those agents.
Okay, and then someone else wants to know if the rules are determined by the state or the federal government.
Generally by the state. So most states have very similar rules about all of these issues, but you're generally governed by the state that you're living in when you draft the documents. So your will, and if you create a trust, it's usually valid in the state where you live, but then if you live in a different state when you die, the rules of the state where you die are going to apply to the will. But for the most part, you're not going to need to update these documents if you move to a different state.
Okay, that's it for now.
Okay. So we're talking about probate assets versus non-probate assets. I also just wanted to mention jointly owned property. Depending on what it is, sometimes that property will also automatically pass to whoever is the joint owner, and not through the will. So just keep in mind that that's usually for sure property that's jointly owned between spouses, real property, depending on the title, bank accounts. A lot of times people do that sort of as a workaround of an estate plan, is they would add their child or somebody to a bank account, and then that bank account just automatically goes to the joint owner when you die. So just, if you have anything like that in place, just kind of keep that in mind when you're thinking through your overall plan. And one of the things I just think is always a good idea when everybody has some time, you know, people say, do we have a lot of extra time while we're home? I'm not sure if anybody has extra time, but if you do, it's always a good idea to do some financial housekeeping while you're doing other housekeeping, and put together an inventory of what your assets are and where they are, and perhaps make a list of this so that if something were to happen to you and somebody needed to come in and either take over your finances for you while you're still alive, or if you passed away, how would your designated person find where everything is? You don't have to share your personal information with that person now, but I think it's a good idea to have a list prepared and let the person know where to find it or how to find it. And you can do the same with it can be accounts, but it can also be passwords and access to social media. And it can really be whatever you think is important. It's a good idea to these aren't legal documents, and this is sort of outside of my specific realm, but I always think it's an important thing while we're at it. Let's make sure the whole package is together so it can be easily administered if it needs to be. And I wanted to do a quick mention of estate taxes, and just to sort of throw out there what the current threshold is for those who don't know. And if you feel that you are over the threshold, you may want to consult an estate planning attorney to try to see if there's anything you can do to reduce or avoid the estate tax burden for your heirs. And where we are right now for 2020 is there's a federal estate tax and gift exemption of $11,580,000. So your estate would have to be over that amount for any federal estate tax to be due. And for married couples, it's twice that. Assets pass automatically without estate tax to a spouse. So your spouse has twice that limit that can pass free of any federal estate tax. It's quite a large number. In New York, the threshold is $5,850,000 per person. It doesn't pass to your spouse. It's basically a use it or lose it rule. But so if your assets are over 5.8 million, or you and your spouse combined is you each have that amount, then I would recommend meeting with somebody to just see if anything you could be doing to make sure you can reduce the burden. And then I think the last thing I just wanted to mention that applies to probably every family and certainly not just writers, but it's something you may want to consider is if you need to do any specific planning for children or family members that have any sort of special needs or disabilities or addiction issues. And even if you don't have a large estate, it's often a burden to leave money to somebody who, if they're on some sort of public benefit, it can affect their ability to receive public benefits if suddenly they have assets. So it's just something that you should consider if there's somebody in your family that falls into that category, just to make sure either you've planned for them the way you want to, or you're not inadvertently screwing up their plan by as crazy as that sounds, leaving assets to them could actually affect them and affect their ability to receive their benefits.
Catherine, do you have time to answer a few questions right now?
Sure.
Okay. So my spouse and I live in different states. Is it complicated to have wills in 2 different states?
No, it depends, and I guess it depends on the state. If you wanted to work with one attorney for your documents for both of you, you could probably do that. Usually, I do separate documents for individuals. Some people will have a married couple might have a joint will. I don't usually do that. So it would be easy to do separate documents for a Connecticut resident and a New York resident or what have you.
Okay, and going off of that regarding states, do you need to update a trust or a will if you move to a different state?
Usually not. It depends on the state. There's certain states that have very costly and lengthy probate process. So California, for example, the probate process seems to just be very expensive and time consuming. So I find that a lot of California residents tend to try to avoid probate as much as possible, and they end up putting all of their assets in a revocable trust so it can avoid the probate process, like even their day-to-day checking account. We don't usually do that in New York. The process is not expensive or time consuming, so it's not that common to do that. So I would say to the New Yorkers that are moving to California, and I guess in this industry that might happen, that might be a pretty common situation. Maybe you'd want to consult with somebody when you get there. Certain states have different rules regarding real property. I think Florida has, there's some language that people usually want to add regarding their real property in Florida. So your basic will is going to be fine wherever you are. If you have specific property that you're concerned about when you get to your other state, you just might want to check in with a local attorney to just make sure you don't need an update.
Okay, and also going off of that, are estate taxes then determined by where you die or where you sign the will, if those happen to be different places?
They're determined by where you die.
Great. Another question. If
I feel like I'm on a game show. I love the question.
Okay, if I die with debt, do my agents and proxies have to pay that debt?
Yes, if there are assets left to pay them. So I get that question a lot. Are my heirs going to be saddled with my debt? No. So the first job of the executor, it's interesting, there must be a really great lobby for the funeral industry, because they're the first people that get paid out of your estate, always. And then your executor, the administrator of your estate, is supposed to pay your debts and then distribute your assets according to either your will or the rule of intestacy. So if there's not enough money to pay your debts, they don't get paid. Your beneficiaries don't get anything, but your heirs aren't going to get, the debt isn't going to carry on to your beneficiaries, if that's part of the question.
Okay, another question about having dual citizenship. Do you need a will for each country, or can you centralize it to just California, for instance?
So that's a really good question. And I hate to sound like a lawyer and say it depends. And I hope I haven't said that too many times already. But in general, for estate tax purposes, the federal government is, no surprise, is going to go after, if you are a U.S. citizen, they're interested in your worldwide assets. Now, fortunately, most people are going to fall under the federal estate tax exemption, so we're not even worried about it. Most countries have a tax treaty, so you're not going to get taxed twice. But as far as the other countries recognizing the will, if that's the question, I usually draft wills so that it applies to all of your assets everywhere that they're located. When I have clients that have assets in other countries, we do sometimes draft a will. You do, as weird as it sounds, you do draft a will, two wills. So it's a will specifically for the property in Ireland and specifically for the property located in the US or in everywhere except Ireland, for example. If you want the property in Ireland to pass to the family that still lives there and be dealt with there, and then we can carve it out. What often happens is we talk about doing that and nobody gets around to doing the second will in the other location. So what I usually build in is like a fail safe of this is, I may have created a will in Ireland that applies to my Irish property and that should be dealt with there. And if it doesn't, if I haven't, then this will applies to all of my property. So we can do both. But I guess the short answer is we can have one will in the US that applies to the worldwide property.
Great. To avoid financial problems or someone taking over, how would one create a foundation?
Okay, to avoid, that's a big question. You can create a foundation. I have a recommendation of a great firm and who can help you with that if somebody wants to contact me offline.
Sure, and you can always write into the BA help desk as well, and we can connect you guys.
And then you can still have a very simple estate plan that directs some or all of your assets or your copyright to go to that foundation.
Okay. What happens to copyrighted material if there is not enough money to pay debt? That's
a good question. Can your creditors attach to the copyright? Deborah, do you happen to know that through the management agency? I actually don't know.
I don't know. But again, I would just say, since we don't know offhand, maybe just write into the help desk and we'll try to find out for you. Not sure.
Okay, and now we actually have a question for you, Deborah. Do you have to be produced or published to have the DG manage your literary estate?
Oh, okay. So we're going to talk about this a little bit more later on, so I might want to just hold on that question. But right. If you want to go to the dgcm.org, you can certainly see the qualifying works. We usually look for works that are professionally produced, published by a third-party publisher, or recorded and distributed through standard channels of commercial distribution. So a third-party company, something like that. So you can take a look at our on the DGCM website to see if your work qualifies. If not, there's always an option of the DG library as well, which we can talk about in a moment. I don't want to override Catherine's amazing content. I have her outline, everyone, and you want her to get through the outline.
we're getting there. We're getting to the good stuff. Looks like there's maybe one more question?
Yeah. So if in your estate plan, everything is held in trust and you have designated who is to receive after death, but you die with debt, how will that debt be paid? Does it depend on the state in which you live?
So, the question is, can your creditors reach something that's already in the trust?
Yes.
And if you've already transferred it into the trust, usually it's a living trust, so you do own those assets when you die. So I guess it depends on the trust. So if you effectively transfer it and you don't own it, a trust owns it, then it would be protected from creditors. But anything that you still own when you die would be reachable by your creditors.
Okay, that is it for now.
Okay, so I wanted to just move on now to specifically what happens to your written work. I wanted to talk about it still while you're still alive, in the event of your incapacity, and then when you die. Have you planned for what's going to happen to it and who's going to be in charge of it? And I think, and then that will lead to ultimately the options of appointing a literary or a cultural executor, which is your topic for your next discussion. So again, I'm big on housekeeping. I want everybody to think about what your current arrangements are regarding your written work. If you've written anything with anybody else, is the division of the ownership and copyright clear? Do you have that documented somewhere somebody else could find the documentation? And have you registered your copyright with the U.S. Copyright Office? Is that something that you work with the Guild members to do?
Sure. Yeah. I mean, we won't register the copyright for them, but we'll send them to the website and help them along if they have trouble filling out the form. But that's certainly something that you want to start doing. I would think sooner, now, today even. There's
Right.
no real reason to wait on that.
And then I just wanted to talk about, what happens to your copyright when you die in terms of passing through your estate or your will if you don't have one. And I think it's important to remember that copyright is considered personal property. So it's like your stuff, like furniture or jewelry or what have you. So that if you don't specify in your estate planning documents what you want to happen to your copyright, it would be lumped together with your personal property, and your executor or the administrator of your estate would get to decide what to do with it, just like they would get to decide how to distribute, as crazy as that sounds, your furniture. It's not like a bank account or that type of asset. So I do think if it's meaningful to you who receives your copyright, if it's a group of people, if it's a charitable organization, it's really an important thing to take the time to plan for. And then I also just wanted to point out that and maybe you talked about this last week, that your drafts and your notes and your notebooks, those are also part of what's often in your estate plan sort of lumped together as all my personal property. And if there's something that you want dealt with in a special way, then you really need to point that out to your executor or, and have a written plan of what's supposed to happen to those belongings.
So you would say to go by, make a big list of everything you've written, right? And then assign them to specific people. Otherwise, it would all get lumped up and given to whoever is receiving under your will or receiving under the law.
Possibly. I mean, I think that you can generalize, you might want somebody to be in charge of your notebooks and your unpublished work, for example. And that might not be the same person who, and we should get to this, that you can divide up how you think about who's going to receive what. And I usually like to think of it in perhaps three different piles of the possession of what's sort of physical property, like notebooks, drafts on your computer, what have you. Your financial beneficiaries, who's going to receive the royalties of your work, if hopefully there is some, and then who should control your work. And that can be that person can take one or two roles of managing your work financial perspective or for your personal legacy cultural perspective? Who can make decisions about how the work can be used in the future? I think this is probably a bigger topic, which you all would have more to say about, is that I think it's hard to distinguish between the literary or cultural executor, trustee, and the financial person, because those two things can be so intertwined or would conflict with each other, that it seems like it would be difficult to separate that into two separate roles. I think it would make sense to have one person do that, or have a panel of people do that, or a management company do that you trust, that would make the right decisions financially and can also continue your personal vision. But you know, what I do in my role as an estate planning for families in general is try to prevent fights in the future. And that's just always the goal, is, you know, if you can figure out now possible problems later and try to prevent them, I think that's the best idea. So that's why when you're thinking about a beneficiary for, let's say, your copyright and royalties and something that's going to be going on for a long period of time, if you have more than one beneficiary, it's going to be challenging for a group of people to make decisions. So that's why we talk about appointing a literary trustee or executor, so that you can avoid the family squabbles or the friend squabbles or the squabbles between the two different charitable organizations, and put somebody in charge that can just make the decisions, and make decisions that are the most like the decisions you would make if you were still here to make them. That's the goal. And what's challenging is that a lot of people just don't have people in their family or in their life that they can trust to take on that role. So it's really tricky, and I think it can be paralyzing. And I think a lot of people just decide to kick the can and not think about it and not deal with it, and that's unfortunate. So that's my biggest pitch, is to really like think about what happens if you do nothing, and is this really something that you want? And obviously it's usually not. So is this a good time to talk about the option of appointing the guild as a managing agent?
Right. So you know, again, the DGCM, it's called the Dramatists Guild Copyright Management. And we are an estate planning consultancy and intellectual property management program that was created by the Dramatists Guild. And we manage copyrights that are left to the Guild or left to one of the Guild's sister organizations. So the Lilies, the DLDF, the Foundation. If you want to leave works to these organizations, you can engage the DGCM to manage those properties. We're a public purpose corporation, which means that our primary focus and our primary drive is really the protection of authorial intent. So unlike some other literary executors that you might get to manage property, they might be fueled by increasing profits. We're always looking towards what is it that you wanted. So, you know, part of our onboarding process is an in-depth onboarding form where we ask you all about your authorial intent. How would you want to make decisions? Do you want to be somebody whose work adapts over time, or is the letter that you've written there, that's the final word? We are very fortunate because we can tap into the Guild's council. So we have a committee within the Guild council that acts as a proxy for the deceased author. So you can always ensure when leaving a work to be managed with the DGCM that decisions are being made by authors, by writers, by the best and the brightest that are really out there at the time. And in addition to that, the DGCM has a goal of really promoting the name and the career of the writer who has left this work. So it's not just about the work that you've left with the Guild or the foundation or the Lilies or one of these organizations, but about who you are and trying to celebrate that legacy for years and years to come. You know, this is really a wonderful way to give back to the Dramatists Guild or one of the other organizations that was maybe there for you during your lifetime. It's also a useful option if you perhaps have an heir that is not interested in managing a work, where we could set up some option with your attorney to get a stream of income going to a beneficiary with the remainder of the income going to the Guild. You could take a look at the details of the program at the dgcm.org. We talked before a little bit about qualifying work. So it's not necessarily every work that will qualify automatically for a Guild management under the DGCM. We do look for works that are professionally produced, published by third-party publishers, and recorded through, you know, commercial distribution channels, third-party companies. We also accept works that were written by an author that has another work that has done one of these things. So if you had a work that was published through a publisher, but that's not the work you want to leave the Guild, we'll still accept a secondary work, so long as the author himself or herself has gone through and qualifies under these criteria. Another alternative, you know, the thing with DGCM, it is a gift. You are gifting your copyright to an organization, to the Guild, or to one of its sister organizations. The other option is really also the Guild Library, which is a new creation. It's still figuring itself out, but that is also a program that we're starting, where you can gift to the Guild, but there's no necessary active management attached to that. So DGCM as an organization would not be managing that work, but you could leave it to the Guild, and then if somebody wanted to license that work, of course the Guild would be the organization to respond to that request. That too is at this moment a gift, and we're continuing to discuss and happy to take feedback from all of our members on sort of what they would like to see. Of course, a lot of people want us to manage works, but we can't manage our members' works. They're your works, to figure out what you want to do with them. And we have a certain liability as well. So we want to be a little bit careful with some of this. But, you know, those are two options, and I would invite you to take a look at our website, thedgcm.org, to read a little bit more about both of those programs. And you can always shoot us any questions through the BA Help Desk or through the DGCM website as well. So those are just two things that might be useful to you in planning your estate. But I think the important thing is to make a plan, like Catherine was saying. And these works are things that you have slaved over for many, many years, and you want to make sure that they're well taken care of as well. You know, just like you plan for what you want your kid to get, well, what are you going to do about your play? So you know, we could take questions on any of that as well. I think I saw a couple.
Yeah. I donated my work, letters, journals, published and unpublished plays, novels, film scripts, written to the Frank Melville Library, where they created my archive. I was wondering if they control that work after my death as well. Do I mention that in my will for my literary trustee?
So the work's already been given.
Right, yeah.
So yes.
Yeah.
It doesn't, it doesn't, well.
Isn't there a difference though between, you know, I gave you a physical copy of my play versus I gave you the copyright in my play? So it might depend on what given meant.
Yes.
In that question.
And I think that there is an exception to the transfer of copyright during your lifetime, where there is a one-time sort of give back to your family. So it is very important in those circumstances, if you want the copyright specifically to continue to be owned by the organization that you gave it to already, to have a will that repeats this gift. or reinstates the gift that you are giving all of your copyright to that institution.
And can you talk more about that? Actually, I think that's a really good point to remember, that if you don't give your copyrights through, and correct me if I'm wrong on this, if you don't pass your copyrights through a will, then any heir could have the potential, could have the right to sort of invalidate any grants that you're making.
Correct. Correct. It's a period of time. I believe it's 35 years. Then that they have the right to take it back. But then they only have that right for a shorter period of time. But it's something I think it's an important issue to dig into if you've given something away during your lifetime and you don't want it to unravel, to repeat your intentions in your will. Does that make sense?
Yeah, I think so.
Yeah.
If not, write in again. And
Yeah.
try again.
Okay, another question. In wording the will, should I say I leave my copyrights to X, or I leave any future royalties to X?
You should specify the copyright.
Great. Is it absolutely necessary to register one's copyright with the government? It is in place already. Thinking about saving money here.
Now, Deborah, maybe you can respond.
I mean, I don't know. I mean, in terms of a will, I don't know if it makes a difference for creating your will to have a copyright to registration. I'm not sure about that, but I mean, that's not really an area where you want to save money. That's the way you're going to protect yourself. If anybody infringes upon your work, you're going to have that work registered. You're creating a public record that this work exists. Plus, anytime you're going to get published, anything like that, they're going to want that registered as well. So there's going to come a time where registration is really necessary. Do you have to register to have a copyright? No, but if you want to protect your work properly, and this is during your life, this is today, then that's not really an area to save that money. You could potentially bundle works together to save money, or register them as a collection of some kind, perhaps. And you could talk with the Copyright Office as well. They have a helpline about, what are the right or wrong ways to do that, or you can call us at the help desk as well. But I don't know if through the will, does it have to be registered to pass through, a will? I would think.
No, I think that's correct, that you own your copyright as soon as you create the work, but it certainly makes the life easier for your heirs and your executor if it's registered, and it's easier to protect it if it's registered.
Okay, what activities are involved for family who become the literary executor? Copyright, in terms of copyright and care of the archive.
So, like, what do they need to do?
Yes.
To do that job? Well, I think that it's important for the person appointing the literary trustee or executor to try to envision that role and what they want them to do. It can be broad or narrow. They can be asked to be an advisor to the family, or they can be completely in charge of decision making. You should think through, do you think they should get paid for their work? And if they do, how are they going to get paid? So it can be tailored in any way that the writer sees. There are a lot of options.
And you can tune in next week as well, because we're going to get to talk to a literary executor who's doing this.
That's
so
great.
You can always write in questions ahead of time, and we can try to get those to him during the program.
Okay. If you want to leave copyright to X, but you want to divide royalties, or what if you want to leave copyright to one person, but you want to divide royalties among 3 people? So what if you want to leave the copyright to just one person, but then have 3 people receive your share of the royalties?
I'm not sure if you can divide it that way. I think that you need to have practically speaking, and this kind of circles back to some of the policies of the DGCM, is that it's ideally somebody has a majority interest and they get to be the decision maker. If you don't haven't appointed someone who's just the decision maker. But is that what the question is? So that somebody would be controlling the copyright but not receiving all of the income?
Yes, I believe so.
You could potentially have somebody controlling the decision making with just the income going wherever you wanted.
Right.
But I suppose the more times you divide it, the more of a burden it becomes. So I guess you'll do what you need to do.
Okay, another question. Well, there's many more. Hopefully we can get to most of them. After my executor/trustee dies, how does it go to their children? In my case, it would be a brother or nephew.
So just like the other documents we've talked about, you can name backups to your backups to your backups. You can also, in terms of a trustee, or if you have a trust document that's a trust that's holding your copyright, for example, you can state in that document that the last name trustee can appoint a successor if you've run out of choices. Or we can say the beneficiaries, if there's nobody left, you can have your beneficiaries choose a new trustee. So maybe you say in your document, either for a trustee or even a literary trustee, you can say, my beneficiaries should never act as the trustee, but they can appoint a new person when this person dies or quits.
Okay, we have a DGCM question. If one uses DGCM, do Sam French and all royalties then just go directly to the DGCM?
Well, keep in mind the DGCM is not collecting your royalty. The royalty is going to the sister organization, to the Guild, to the Lilies, to wherever you've chosen to leave the copyright. We're just managing it. So we would work with your agents to make sure that those things are happening properly. We do take a percentage just for the management, but then we would also reevaluate all the relationships that we've got going on. Are they working to your benefit? Are there better choices we can make? So it would not go to DGCM. All the royalties are ultimately getting pushed to the organization that you left the copyright to.
Okay. I have a fairly simple estate. Is it feasible to write my will and supporting docs through an online service?
I don't know, because I have never actually looked at those forms, but maybe. I wouldn't advise it.
Okay, I was going to say,
but,
I wouldn't advise it.
And I think that, I hope, this wasn't an intimidating seminar, but I do think that dealing with copyright is important, and it is somewhat complicated, so that it's nothing to take lightly. I do think that you can probably find very general forms that work for most property, but what we're here to talk about is that your property is very special, and they're taking care of it is different than bank accounts and other types of property, and so it does need to be carefully considered.
Okay, what is the price range for setting up the documents we discussed today?
I think you probably find again, depending on the law firm that you work with, in New York City, there's a very wide range of fees out there. I guess they would, I would say that they range from, an estate plan would probably range from $1,500 to $5,000, depending on your situation and who you choose to work with.
And I know we have a lot of questions, but we're also at 4 o'clock. So
Yeah. Do we want to maybe just do one more?
sure.
Okay. This will be a quick one. Can one just include the DGCM assignment in one's will?
Well, again, you wouldn't be assigning anything to the DGCM. The DGCM is just the company that the guild or one of the sister organizations is really going to hire. So your directive in your will is to have the DGCM management. But no, you don't want to do that, because if it's not a qualifying work, then the DGCM wouldn't be managing it. You can, however, leave your work to the guild, and then the guild would have to decide at that time that it becomes relevant whether or not to accept that gift. Does that sound right, Catherine, too? right? Because just because you leave something to someone doesn't mean they have to.
And I think that happens a lot with people's personal art collections, that they leave it to certain museums or organizations that can't accept it for whatever reasons, and that can get complicated. So I think that it's worth your time to make sure that whoever you're leaving your assets to is someone who can and wants to accept it.
Okay, great. So listen, thank you all for joining us. Thank you, Catherine, so much. I think we've got so many more questions, and I would encourage people to write into the help desk or get in touch with Catherine if you'd like to talk more.
Please contact me offline if you have any other questions.
I will make her information available to you, and I hope that you'll all join us next week for Who Tells Your Story Part 3 with literary executor David Saint, who is the executor over the Arthur Lawrence estate, and it should be a really interesting conversation. So send in your questions ahead of time, and we will see you then. Thank you so much, and thank you, Kristen.
Thank you.
Okay, bye-bye.